This film examines courts that legalized disappearance through technicalities and delay. It is a history of legal rooms where people entered alive, named and accounted for, and then slowly vanished, not through violence alone, but through procedure. What you are about to hear concerns judges, clerks, petitions, and calendars, and how time itself became an instrument of erasure.br. In the public imagination, disappearance is sudden, a knock at night, a body removed, a road with no return. Yet, in many legal systems of the 18th and 19th centuries, disappearance was gradual, bureaucratic, and entirely lawful. It occurred in daylight, it occurred in writing, it occurred because the court did nothing, and because doing nothing was permitted. Across Europe and the United States, courts inherited a profound power, the authority to recognize a person's presence or to suspend it. To be legally present was to be visible to the state. To be delayed was to be suspended between acknowledgment and oblivion. The law did not need to declare a person dead. It only needed to postpone deciding whether they were alive. The record books remain. Heavy ledgers, bound in leather, written in careful hands. Names appear once, sometimes twice, and then not again. The absence is not dramatic, it is procedural. A hearing postponed due to docket congestion. A petition misfiled. A writ returned unanswered. A clerk unavailable. A judge traveling. Each delay lawful. Each delay justified. In English common law, the writ of habeas corpus was intended as a protection against unlawful detention. It required that a detained person be brought before a judge. But the writ relied on response, and response relied on time. Jailers could claim illness. Sheriffs could claim distance. Courts could claim recess. The law demanded appearance but did not always demand urgency. Men and women accused of vagrancy, debt, sedition, or moral offense were often held without trial while papers moved slowly. Some died waiting. Others were transferred between facilities, their names altered or misspelled. Some were released quietly and left without documentation. When families petitioned the courts, they were told the matter was pending. Pending was a word with power. Pending meant no resolution. Pending meant the law acknowledged a question but declined to answer it. Pending meant the person existed somewhere in the system even if no one could say where. Pending meant the court remained blameless because it had not yet decided. In colonial America, this delay was weaponized against the poor, the enslaved, and the politically inconvenient. Enslaved people accused of crimes were sometimes held without trial because their legal status complicated jurisdiction. Were they property or persons? Courts deferred, owners waited, jailers charged fees, the accused remained unseen. Free black citizens faced similar erasure. When arrested under vague statutes, they could petition for hearings that never came. Clerks recorded filings but not outcomes. A person could exist in the margins of the docket, neither convicted nor acquitted, indefinitely detained or quietly removed to labor camps, roads, or distant counties. In debtor courts, delay served creditors. A debtor held in prison could not earn, but could be charged for confinement. Appeals extended confinement. Continuances extended fees. Judges rarely questioned the duration. The law treated time as neutral, though it crushed one party and benefited another. Women who challenged guardianship, confinement, or forced institutionalization faced a particular form of disappearance. When a husband or male relative petitioned a court to declare a woman unfit, the court often ordered evaluation. Evaluation took time. During that time, the woman could be confined, her testimony postponed until doctors submitted reports delayed by travel or illness. Months passed, sometimes years. By the time a hearing occurred, if it occurred at all, the woman's absence was used as evidence of her incapacity. She had not appeared. She had not spoken. The court did not ask why. In these systems, the calendar was not merely administrative. It was moral. Judges understood that delay favored order over justice. A resolved case risked controversy. An unresolved case remained safely theoretical. The person at its center became an abstraction. Families wrote letters. They traveled to courthouses. They waited on benches. They were told the judge was unavailable. They were told the file could not be found. They were told the matter was under review. Over time, some stopped asking. Others died. The case remained open. Newspapers occasionally noticed. A brief column might ask what had become of a man arrested 3 years prior. The court replied that proceedings were ongoing. No further comment. The story ended. Disappearance through delay left few bodies and fewer crimes. It left paper, and paper rarely convicts. Each official acted within authority. Each step complied with rules. Responsibility dissolved across offices in weeks. In appellate courts, delay became insulation. Appeals were granted not to overturn convictions, but to suspend them. A person in limbo could not challenge the system effectively. By the time a decision arrived, witnesses were gone, memories faded, and urgency evaporated. Some legal scholars of the era defended delay as caution, better to be slow than wrong. Yet slowness was not evenly distributed. Those with wealth moved faster, those without waited. The law measured time differently depending on who was asking. In frontier territories, where courts met infrequently, delay was unavoidable, but it was also exploited. A judge might convene twice a year, prisoners held until then might be transferred before the session, their cases postponed to the next term. The law never caught up with them. The most complete disappearance occurred when a person died while legally unresolved. Death closed nothing. The court simply noted the cessation of proceedings, no ruling, no acknowledgment of harm. The file closed itself by silence. Descendants searching records generations later encountered these absences. A name, a date, an accusation, and then nothing. No sentence, no release, no burial. The law did not record the end because it never reached one. This history does not accuse individual judges of malice. It examines a system that understood delay as harmless. It reveals how neutrality can erase, how patience can kill, how waiting can become a verdict. The courts did not drag people into darkness. They allowed darkness to grow while they reviewed their calendars. And in that space between filing and hearing, between motion and response, thousands were lost. Not taken, not executed, simply delayed until the world moved on without them. The ledgers remain open even now. Their silence is complete. The silence of those ledgers was not accidental. It was cultivated. Courts learned early that delay produced fewer enemies than decisions. A ruling creates a record of responsibility. A postponement creates nothing that can be overturned. In this way, legal systems discovered a form of power that required no force, no spectacle, and no explicit cruelty. It required only patience. In the 19th century, as legal bureaucracies expanded, delay became standardized. Courts introduced formal continuances, adjournments, and stays. Each was justified as procedural fairness. Each extended the life of uncertainty. Judges rarely framed these pauses as harmful. Harm was understood only as punishment without sentence. Waiting did not qualify, yet waiting stripped people of identity. A person awaiting judgment could not remarry, could not inherit, could not relocate without risk of forfeiting their claim. They existed in a suspended state, legally incomplete. Communities treated them cautiously. Employers hesitated. Churches withheld rights. The law had not condemned them, but it had marked them as unresolved. For those accused of political offenses, delay was a quiet solution. During periods of unrest, governments did not always need convictions. They needed absence. A dissenter held without trial was neutralized without martyrdom. The court could claim neutrality. The individual could not claim innocence. Time did the work. In some jurisdictions, records show repeated notations, continued. No explanation. No objection recorded. Defense counsel might protest, but the protest itself required filing, which required time. Delay compounded itself. Prisons and holding facilities adapted. They were not designed for indefinite detention, yet indefinite detention became routine. Prisoners aged. Some lost health. Some lost language. When they were finally released, if they were released, their return was quiet. No apology. No restoration. The court had never declared them wronged. In the American South, after the Civil War, delay intersected with race in particularly brutal ways. Freedmen arrested under vague labor or loitering laws were held while courts debated jurisdiction or waited for witnesses. During that waiting, they were leased to private employers, their labor extracted while their legal status remained unresolved. If they died, the case dissolved. If they survived, the delay itself had already achieved its purpose. Northern courts were not exempt. Immigrants accused of minor offenses often faced language barriers that slowed proceedings. Interpreters were scarce, documents mistranslated, hearings postponed. Some were deported before their cases concluded, effectively erased from the docket by distance. Women confined to asylums encountered courts that deferred to medical opinion. Judges requested evaluations, physicians delayed, reports contradicted each other. While experts debated, confinement continued. The law framed this as caution. The woman experienced it as disappearance. The phrase justice delayed is justice denied was known but rarely enforced. Courts acknowledged it as a principle, not a mandate. There were no penalties for delay, no accounting for time lost, no measure of damage. Families who persisted learned the language of patience. They learned which clerks to approach, which days judges were receptive. They learned to wait quietly. Those who spoke too loudly risked contempt. Silence was safer. Silence extended the process, but it preserved access. Some courts maintained inactive dockets. Cases placed there were neither closed nor pursued. They could remain untouched for decades. The court could claim transparency. The case was still listed, yet nothing moved. When reforms came, they addressed outcomes, not time. Laws clarified crimes. Sentences were standardized. Procedures refined. But the calendar remained sovereign. Courts continued to control when justice would occur, if at all. In rare instances, delayed cases resurfaced unexpectedly. A new judge reviewed old files. A journalist asked questions. A descendant filed an inquiry. The court responded with fragments. The person's fate remained unclear. The delay had done its work too thoroughly. This form of disappearance leaves no single villain. It leaves a structure, a belief that time is neutral, that waiting is benign, that unresolved suffering is preferable to decisive error. It asks viewers to consider how many lives were spent in that space between acknowledgment and action. The law prides itself on permanence. Statutes endure. Precedents persist. Yet delay reveals its fragility. A system that governs time governs existence. To be postponed is to be diminished. Even today, historians encounter these gaps. They do not know whether a man walked free or died in custody, whether a woman returned home or was buried under an institutional name. The court never said, and because it never said, it never had to answer. These disappearances were not hidden in secret rooms. They occurred in public buildings, during office hours, under seal and signature. The cruelty was not that the law acted, but that it waited, and waiting, repeated often enough, became a method. The method persisted because it required no justification beyond procedure. Judges spoke of balance. Clerks spoke of backlog. Legislators spoke of reform without urgency. The human cost remained abstract, dispersed across years and files. In many jurisdictions, the responsibility for moving a case forward rested with the accused. They were expected to petition to remind the court of their own existence. Failure to do so was interpreted as acquiescence. Yet petitioning required access, literacy, and endurance. Those without these resources faded quietly. Legal disappearance also occurred through jurisdictional confusion. A person arrested by one authority and claimed by another could be held while courts negotiated responsibility. Federal and local courts deferred to each other. Colonial administrations passed cases back to metropolitan centers. While authority shifted, the individual remained confined. Extradition cases were especially prone to delay. A person accused in one territory but held in another could wait years for paperwork. Diplomatic correspondence moved slowly. Each government insisted on form. The accused lived in suspension, punished without verdict. In maritime courts, sailors accused of desertion or mutiny were often held until the next circuit session. Ships sailed, witnesses departed, evidence evaporated. The sailor remained. By the time a hearing occurred, the case relied on presumption rather than fact. The law accepted this erosion as natural. Time was not considered an actor. It was a backdrop. Yet time altered bodies, memories, and lives. Delay functioned as a sentence without length. Some judges recognized the danger and spoke against it. Their words survive in marginal notes and dissenting opinions. They warned that prolonged uncertainty was itself a form of punishment. Their warnings rarely changed practice. The system rewarded caution, not speed. Public confidence in courts rested on ritual rather than outcome. The sight of a courtroom, the sound of formal language, the presence of robes and seals suggested order. Few questioned how long matters remained unresolved behind those symbols. For the disappeared, there was no ceremony, no closure, no acknowledgment of harm. When death occurred in custody, it was recorded as incidental. The case closed by default. The delay absorbed the loss. The absence of scandal was itself evidence of success. A delayed injustice does not provoke immediate outrage. It dulls, it exhausts, it outlives those who might protest. This history challenges the assumption that cruelty requires intent. Systems can harm through indifference. They can erase without decision. They can destroy by waiting. As you listen, it is important to resist the comfort of distance. These courts believed themselves rational and humane. They operated under laws admired for stability. Their cruelty was not obvious. It was procedural. The ledger does not weep. It does not explain. It simply stops writing. And so the question remains, not of what the courts did, but of what they allowed time to do on their behalf. The allowance of time became a habit, and habits hardened into doctrine. Legal manuals of the late 19th century instructed clerks on how to manage delays, not how to prevent them. Efficiency was defined as orderly postponement. A case properly delayed was considered under control. In court correspondence, language softened the reality. A person was not confined, they were held pending review. They were not forgotten, they were awaiting disposition. These phrases removed urgency. They implied motion without movement, care without action. When delays were challenged, courts responded with arithmetic. They counted filings, sessions, personnel. They did not count days lost by individuals. Time was measured institutionally, not humanly. The calendar belonged to the court, not to those bound by it. Legal disappearance also relied on fragmentation. One office held arrest records, another held detention logs, another managed court schedules. No single authority saw the whole. When families asked questions, each office answered honestly and incompletely. The truth was distributed, thinly enough to be invisible. In some cases, the person was moved repeatedly. Each transfer reset familiarity. New guards did not know the name. New clerks did not know the history. The individual became a temporary presence everywhere, permanent nowhere. Appeals to higher courts often worsened the condition. Higher courts requested records that took months to compile. While waiting, lower courts claimed lack of authority to act. The person remained suspended between jurisdictions, technically protected, practically abandoned. There were moments when delay crossed into recognition. In rare rulings, judges acknowledged that excessive postponement violated basic principles. These cases are cited as progress, yet they are notable precisely because they were exceptions. Most delays never reached such scrutiny. The majority of disappeared cases left no dramatic trace, no protest, no riot, no overturned conviction, just a quiet thinning of presence. A person stopped being mentioned, then stopped being searched for, then stopped being remembered. Historians sometimes mistake this silence for resolution. They assume a missing outcome implies release, or death, or exile. But assumption is itself a continuation of the delay. It fills the gap without confronting it. The cruelty of this system lay in its restraint. It did not lash. It did not declare. It waited. And in waiting, it consumed lives that were never formally taken. To understand these courts is to understand a form of power that prefers absence to accountability. A power that leaves no clear victim and no clear perpetrator. Only time, and the damage time was allowed to do. The lesson is not confined to the past. Any system that controls recognition controls existence. Any authority that can postpone acknowledgment can quietly erase. The ledgers remain heavy and closed, their unanswered cases resting like unresolved questions. They do not accuse. They do not explain. They simply endure. Endurance was the final defense of these systems. Long after statutes changed and buildings were replaced, the unresolved cases remained embedded in archives. They were not revisited because there was no mechanism requiring their return. The law moved forward by leaving them behind. For those who vanished this way, there was no official ending. Their lives did not conclude in verdicts or sentences, but in administrative fatigue. Clerks retired, judges died, files were boxed. The case was not decided, it was outlived. In some regions, fires, floods, and neglect erased the physical records themselves. When this happened, the disappearance became complete. Without paper, there was no absence to question. The law could claim ignorance without dishonesty. Occasionally, a reform commission uncovered these patterns. Reports acknowledged excessive delay as a failure of justice. Recommendations were issued, timelines were proposed, yet implementation lagged. Delay resisted reform because it was never illegal. It was merely unfortunate. The human experience of this erasure rarely entered official language. Letters from prisoners speak of confusion more than anger. They did not know what they were waiting for. They did not know how to end the waiting. Time became shapeless, days indistinct. Some adapted. They learned the rhythm of postponement. They measured life in filings and responses. Others deteriorated. The law did not record this difference. It did not see waiting as a condition requiring care. When a delayed case finally concluded, the resolution often felt hollow. Years had passed. Circumstances changed. Witnesses were gone. The outcome no longer restored anything. Justice arrived, but too late to matter. For families, the absence lingered. They never knew whether to grieve or hope. The court had not declared death. It had not declared innocence. It had only delayed. This ambiguity fractured memory. It prevented mourning. It prolonged uncertainty across generations. The moral weight of this history lies not in malice, but in design. Systems built to be cautious became systems that consumed lives slowly. They avoided error by avoiding action. In doing so, they created a quieter injustice. To look at these courts is to confront a difficult truth. Law does not only harm through harshness, it harms through hesitation. It harms when it values order over presence, procedure over person. The disappeared left no monuments. Their names survive, if at all, as partial entries, yet their absence shaped the legal cultures that followed. Modern doctrines of speedy trial, of due process, of time limits arose in response to this silence. They are acknowledgments, not reparations. Even now, when courts speak of backlog, of congestion, of delay, they echo an older language. The words sound neutral, the effect remains human. This is not a history of secret executions or hidden graves. It is a history of rooms where clocks ticked, papers waited, and people slowly ceased to exist in the eyes of the law. And that disappearance, because it was legal, was never named as such. Because it was never named, it was never fully reckoned with. Legal systems recorded what they resolved, not what they suspended. Absence did not demand explanation. The burden of memory fell instead on families, communities, and, much later, historians who noticed the gaps and tried to measure what had been lost inside them. In some court towns, local memory preserved fragments. A man who never returned. A woman who was taken to the county facility and not seen again. Stories circulated quietly, stripped of detail, because detail invited questions, and questions invited trouble. The court had not declared a crime. Speaking as if one had occurred felt improper. This culture of restraint protected institutions. To accuse a court of disappearance required proof. Proof required records. Records showed only delay. Delay was permitted. The circle closed. Even judges who suspected harm found themselves bound by convention. To accelerate one case invited scrutiny of others. To acknowledge injustice in delay threatened the legitimacy of the calendar itself. Better to preserve the fiction that time was impartial. The architecture of courthouses reflected this priority. Public spaces were orderly, ceremonial, slow. Hallways encouraged waiting. Benches faced closed doors. The experience taught deference to time. Those who waited learned their place. Some legal philosophers argued that delay tempered passion, that justice required distance, yet distance favored those already secure. Those without standing faded from view. The law did not chase them. It did not need to. When nations modernized, they celebrated codification and reform. They pointed to clearer statutes and standardized procedures. Rarely did they audit unresolved past cases. The dead weight of delay remained buried under progress. Archives today still contain files marked incomplete. No final entry, no closing stamp. They sit among resolved cases, indistinguishable at a glance. Only careful reading reveals the absence. Only patience uncovers the silence. For descendants, discovery can be unsettling. A name appears, then dissolves. There is no narrative to inherit, only uncertainty. The law offers no explanation. It never promised one. This history resists dramatic retelling because its cruelty is quiet. There are no villains shouting orders, no sudden violence. There is only the slow grinding of process, the turning of pages, the passing of terms. Yet the effect was profound. Entire lives were consumed by waiting, entire lineages shaped by absence. The courts did not intend to erase, but they accepted erasure as collateral. To confront this past is not to accuse law itself, but to recognize its limits. Any system that treats time as neutral risks repeating this harm. Any authority that controls recognition must be held accountable for delay. The disappeared through technicality and postponement remain unnamed because naming would require admission. Admission would require responsibility. Responsibility would require change. And so the ledgers stay as they are. Not closed, not resolved. Just finished with. Finished with, but not complete. The distinction matters. A closed case suggests judgment. A finished file suggests exhaustion. The court stopped because it could stop, not because truth was reached. In legal culture, exhaustion is rarely examined. It carries no moral charge. Files end because attention ends. Resources shift. Priorities change. The law moves on, leaving unresolved matters as acceptable residue. This residue accumulated quietly. By the early 20th century, some jurisdictions carried thousands of pending or inactive cases. Administrators spoke of them as numbers, not lives. Clearing them meant dismissing without review. Better to leave them untouched, existing in name only. Those who had disappeared through delay were not counted among the wronged. Compensation schemes, where they existed, required verdicts or proven misconduct. Delay produced neither. The harm was real but unclassifiable. Even when courts began to impose time limits, they applied them prospectively. Past delays were regrettable but immutable. The disappeared remained outside reform, stranded in an earlier calendar. The emotional discipline required to endure this system was severe. Petitioners learned to temper hope, to expect nothing, to accept that asking again might change nothing. This resignation was mistaken for acceptance. It was, in fact, survival. Some prisoners marked time by memorizing court dates that never arrived. Others stopped marking time altogether. When release came, it felt unreal. When it did not, expectation dissolved. The law never recorded this inner erosion. The greatest protection of this system was its respectability. Courts were trusted. They were symbols of civilization, restraint, and order. To imagine them as agents of disappearance felt improper. Disappearance was supposed to be violent, chaotic, illegal. This was none of those things. Yet legality does not guarantee justice. Order does not prevent cruelty. And silence, when sanctioned, can be as destructive as force. The disappeared through delay challenge comforting narratives about progress. They remind us that systems can improve while leaving victims behind, that reform can coexist with unresolved harm. Their stories, when recoverable, end without resolution, not because historians fail, but because the law failed to finish what it began. It summoned people into its orbit, then let time erase them. This is the legacy of courts that legalized disappearance through technicalities and delay. Not a conspiracy, not a secret program, but a structure that allowed absence to become normal. The question left behind is not how this was allowed, but how often it is still being allowed, under different names, with different calendars, and the same quiet patience. Quiet patience was the final instrument. It asked nothing dramatic of those in power. It required no declarations, no extraordinary measures. It asked only that nothing be rushed, that every question wait its turn, that urgency be treated as impropriety. In this way, delay became a moral posture. Those who demanded speed were framed as reckless. Those who accepted postponement were praised as reasonable. The law taught society to value composure over resolution, stability over clarity. This posture shaped how disappearance was remembered, if it was remembered at all. Because no single moment marked the loss, there was no anniversary. Because no order declared the outcome, there was no document to cite. Memory thinned with time, just as the court expected it to. In some cases, the individual returned years later, changed beyond recognition. Age, illness, and isolation altered them. Communities struggled to place them. The law had never formally taken them away, and so it never formally restored them. Their return was personal, not legal. Others never returned. Their absence hardened into family legend, then into silence. Descendants sensed a gap but lacked language for it. The law had offered none. This form of disappearance resists outrage because it offers no single injustice to condemn. Each step was defensible, each delay explained. The harm emerged only in accumulation, and accumulation is difficult to prosecute. Yet the accumulation was vast. Across decades and continents, countless lives were spent waiting for decisions that never arrived. The courts did not count them, but they shaped legal reform through their absence. Every later insistence on timeliness carries their shadow. To speak of them now is not to complete their cases. That cannot be done. It is to acknowledge that time, when controlled by authority, is never neutral. It can be wielded even gently as a means of removal. The ledgers remain the final witnesses. They do not accuse the judges by name. They do not describe suffering. They simply show where writing stopped. And in that stopping, a truth becomes visible. Justice does not only fail when it is denied, it fails when it is endlessly postponed. Postponement created a space where responsibility dissolved. No single hand pushed the person into absence. No single order can be cited. Each official touched the process lightly, briefly, and then passed it on. Authority became diffuse enough to feel blameless. This diffusion shaped how courts spoke about themselves. They described systems, not decisions, processes, not outcomes. When questioned about missing persons or unresolved cases, they pointed to complexity. Complexity excused delay. Delay excused harm. In the correspondence of judges, one finds occasional unease, a remark that a case had lingered too long, a note that a prisoner had been held an extraordinary period. These acknowledgments rarely produced action. They existed as moral footnotes, not commands. The legal mind was trained to fear haste more than harm. A rushed decision might be overturned, criticized, remembered. A delayed one faded quietly. Time protected reputations. For the disappeared, this meant there was no moment when injustice was complete. It unfolded slowly, almost politely. They were not expelled from the system. They were kept within it indefinitely until they were no longer able to demand recognition. The language of law reinforced this. To be under consideration suggested care. To be pending suggested movement. The words disguised stasis. They allowed courts to appear active while remaining still. This history forces a reconsideration of what disappearance means. It is not only removal from society, it is removal from conclusion. A person without conclusion cannot be fully mourned, fully defended, or fully remembered. In some cases, religious authorities attempted to intervene. They petitioned for clarity so that rites could be performed, marriages resolved, inheritances settled. Courts responded with caution. The case was not ready. Time was needed. Faith deferred to law, and law deferred to itself. The absence spread outward. Property remained frozen. Families remained divided. Communities adapted to uncertainty as a permanent condition. The court never intended this reach, but it accepted it. When modern observers look back, they often search for intent. They ask who wanted these people gone. The answer is uncomfortable. No one had to want it. The system made room for disappearance without desire. This is the most difficult lesson. Injustice does not always announce itself. It can be built into routine. It can emerge from patience praised as virtue. The courts that legalized disappearance through technicalities and delay did not see themselves as destroyers. They saw themselves as careful, and in that care, they allowed lives to thin into absence. Time did not betray them. It served them. Service through time left a particular kind of wound. It was not sharp. It did not bleed visibly. It settled slowly like dampened walls, weakening structures that appeared intact. Communities learned to live around the gaps. The law learned not to look at them. In later years, when court reformers spoke of efficiency, they rarely spoke of those already lost to delay. The future mattered more than the past. Progress required forgetting. To reopen unresolved cases would have required acknowledging that delay itself had been harmful. That admission was too costly. So the disappeared remained outside the story of reform. They were not martyrs. They were not statistics. They were inconvenient reminders that legality and justice had diverged. In teaching institutions, these histories were compressed into footnotes. Students learned doctrines, not durations. They studied outcomes, not waiting. The law reproduced itself without fully examining the damage caused by its tempo. The silence around these cases was not enforced by threat. It was sustained by decorum. One did not accuse courts lightly. One did not speak of absence without proof. And proof in these cases had been postponed out of existence. Yet absence has its own weight. It presses on records. It disturbs narratives. It leaves questions that do not resolve. For historians willing to sit with that discomfort, a pattern becomes visible, not as a scandal, but as a method. This method depended on trust. The public trusted that courts would eventually act. That trust allowed delay to continue. When action never came, trust absorbed the loss. Faith in the system remained intact because failure was never declared. The disappeared through delay were not erased in one moment. They were thinned gradually until they no longer registered. Their disappearance was not noticed because it did not interrupt order. It was part of order. To name this now is not to undo it. It is to recognize that power does not always strike. Sometimes it waits, and in waiting, it decides who will still be there when the calendar finally turns. When the calendar finally turned, it often turned past the point of remedy. What remained was not injustice in motion, but injustice settled into the background, normalized by familiarity. The court had not failed in any visible way. It had simply persisted. Persistence can be deceptive. It suggests stability, reliability, endurance. But here, persistence meant that unresolved lives became part of the landscape. Like abandoned buildings, they were noticed at first, then avoided, then accepted as permanent features. In some communities, people learned not to expect resolution. Arrest did not imply trial. Petition did not imply response. The law became something one endured rather than engaged. This quiet resignation was mistaken for respect. The power of delay lay in its ability to exhaust opposition without confrontation. There was nothing to protest against except time itself, and time cannot be summoned, cannot be cross-examined, cannot be held accountable. Even those who benefited from the system rarely noticed. Creditors recovered assets while cases lingered. Employers exploited detained labor. Authorities maintained order without public trials. The absence of decision served many interests without announcing itself. As decades passed, these practices shaped legal temperament. Judges learned to value restraint. Clerks learned to manage backlog rather than prevent it. Legislators learned to speak of reform without urgency. The culture of delay reproduced itself quietly. The disappeared were never formally counted, but their absence influenced later legal safeguards. Time limits, speedy trial rights, and procedural deadlines emerged as responses to a harm that was difficult to name. These reforms acknowledged something went wrong, without fully saying what went wrong was not merely inefficiency, it was a moral miscalculation. The belief that harm only occurs when action is taken, not when it is withheld. The belief that waiting is neutral. History shows otherwise. Waiting can be directed. It can be selective. It can be devastating. The courts that legalized disappearance through technicalities and delay did so without spectacle. Their authority rested on calm language, orderly rooms, and the promise that time would eventually clarify everything. For many, it never did. What remains is a question carried forward, not answered. How many lives were spent in that waiting? How many stories ended without ending? The law did not record them, but their absence still shapes the space where justice claims to stand. That space is quiet, and it is deliberate. Justice prefers noise when it arrives, but silence when it hesitates. The disappeared through delay occupy that silence, not as evidence, but as absence that must be inferred. What makes this history difficult to confront is its familiarity. Delay is still spoken of as inconvenience rather than injury. Courts still measure time in dockets and terms, not in human cost. The language is softened, the procedures refined, but the underlying assumption remains that waiting is safer than deciding. In the past, this assumption allowed entire categories of people to slip beyond recognition. Those without wealth, without allies, without literacy, without patience. The law did not single them out. It simply moved at a pace they could not survive. The moral horror lies here, not in cruelty performed openly, but in suffering rendered invisible by routine, in a system that could look directly at delay and see nothing wrong, because delay did not violate any rule it recognized as binding. Rules are not the same as ethics. Courts obeyed their own procedures, and in doing so, violated the lives entrusted to them. The contradiction was never fully acknowledged, because acknowledging it would have required a different understanding of responsibility. Responsibility, in these systems, ended at action. If no action was taken, no harm was recorded. The space between arrest and judgment was treated as empty. In reality, it was where lives were altered beyond repair. The disappeared through delay remind us that power can be exercised passively, that authority does not always command. Sometimes it withholds, and withholding, when prolonged, can erase as effectively as force. This is why their stories do not resolve. There is no single moment to point to, no order to condemn, only a pattern, repeated until it felt normal. To sit with this history is uncomfortable. It offers no villains to denounce, no triumphs to celebrate. It offers only a caution that systems designed to protect can harm when they forget the weight of time. The courts believed that by waiting, they preserved justice. What they preserved instead was their own stability. The cost was borne quietly by those who waited until there was nothing left to wait for. The ledgers closed not with answers, but with silence, and in that silence the disappeared remain, not as ghosts, but as unresolved questions the law never finished asking. Those unresolved questions linger because the law never learned how to account for time as harm. It recorded acts, not durations. It punished crimes, not waiting. In doing so, it created a category of suffering that fell outside judgment. The disappeared through delay were not anomalies. They were the predictable outcome of a system that valued procedure over presence. Once that priority was established, disappearance required no intent. It emerged naturally, like sediments settling at the bottom of a river. In some cases, officials recognized the human cost but felt powerless to intervene. They spoke of institutional limits, of rules they could not bend, of calendars already full. Responsibility was always elsewhere, deferred just like the cases themselves. This deferral shaped moral imagination. When harm has no moment of occurrence, it becomes difficult to feel. Sympathy fades when suffering has no clear beginning. Outrage dissolves when there is no decisive act to condemn. The law benefited from this diffusion. It remained authoritative, orderly, respectable. Its failures were slow enough to escape attention, gentle enough to appear benign. Disappearance became an administrative byproduct rather than a scandal. Yet for those inside the system, the experience was anything but benign. Waiting without end reshaped identity. A person became someone whose life was on hold. Decisions postponed other decisions. Marriage, work, movement, even hope, all deferred. The law did not see this cascade. It saw only a case number and a status, pending, under review. Continued. To understand this history is to recognize that justice is not only about outcomes, but about tempo. Speed can be dangerous, but slowness, unexamined, can be lethal. The courts that legalized disappearance through technicalities and delay did so by mistaking restraint for virtue. They believed that by avoiding decisive error, they avoided injustice. What they created instead was a quieter, more enduring harm. This harm did not announce itself. It accumulated. It waited. It relied on patience praised as civility. And when patience ran out, the law had already moved on. The unresolved cases remain as negative space in the historical record. They are not stories with endings. They are interruptions that never resumed. Their lesson is not that the law was cruel, but that it was incomplete. And incompleteness, when prolonged, can erase a life as thoroughly as any sentence. Incomplete systems tend to defend themselves by pointing to intention. They argue that harm was unintended, that no rule was designed to erase, but history is shaped less by intention than by effect, and the effect of legalized delay was a population that slipped out of recognition without ever being formally removed. What distinguished these courts was not cruelty of temperament, but confidence in structure. Officials trusted that process itself was protective. If each step followed the rule, then the whole must be just. This faith left little room to question what happened between steps. Between steps is where life occurred. Days spent confined, months spent waiting for a name to be called. Years spent believing that resolution would arrive with the next term, the next judge, the next letter. The law did not mark this passage. It treated it as empty. This emptiness was an illusion. Time pressed on bodies and minds. It altered relationships. It consumed opportunity. By the time the court was ready to act, the person who had entered its orbit no longer existed in the same form. Yet the court addressed the case as if nothing had changed. It read old accusations, old statements, old facts. It assumed continuity where none remained. Justice arrived out of alignment with reality. In some instances, this misalignment was quietly acknowledged. A judge might note that too much time had passed to proceed fairly. The case would be dismissed, the person released. The record would show mercy. It would not show the years lost. Dismissal without acknowledgment completed the disappearance in another way. It ended the legal story without ever telling the human one. The person walked free, but unrecognized as wronged. The delay vanished from the record. This pattern taught institutions that delay carried little risk. Whether a case ended in conviction, dismissal, or silence, the harm of waiting was rarely named. It did not appear in statistics. It did not threaten legitimacy. The disappeared through delay therefore occupy a peculiar place in history. They are victims of a system that never accused itself. Their suffering is implied, not documented. To find them, one must look for what is missing rather than what is written. This demands a different kind of attention, not to dramatic moments, but to long stretches of nothing, not to decisive acts, but to prolonged inaction. It requires listening to silence as evidence. When we do this, a pattern emerges that challenges comfortable narratives about law and progress. It shows that restraint, when unchecked, can become neglect. That caution, extended indefinitely, can become cruelty. The courts believed they were preserving order. What they preserved was delay itself, and delay, once normalized, became a tool no one needed to claim. It simply waited. Waiting does not require maintenance. That was its advantage. Unlike violence, it left no marks that demanded explanation. Unlike verdicts, it produced no language that could be challenged. It existed comfortably within the rhythms of institutions already accustomed to moving slowly. Over time, this normalized absence reshaped expectations. People learned that entry into the legal system did not guarantee exit, that acknowledgment did not imply resolution, that a name spoken once in a courtroom might never be spoken again. The courts did not deny this possibility. They simply did not address it. Their silence functioned as permission. As long as no rule was broken, no correction was required. Delay, after all, was not failure. It was patience. This patience insulated authority. A delayed injustice rarely gathered momentum. It exhausted attention. By the time concern arose, it had already aged into something difficult to revive. The law counted on this fatigue. It did not need to be cynical to benefit from it. What emerges from this history is a portrait of power at its most restrained and most damaging. A power that does not strike, but withholds. A power that does not declare, but postpones. A power that does not end lives, but slowly removes them from recognition. The disappeared through delay were not erased by decree. They were worn down by time managed by others. Their absence was the outcome of a system that mistook endurance for justice. To recognize this is not to reject law, but to demand more of it. To insist that time be counted as part of judgment, not as an empty space between decisions. To remember that waiting, when imposed, is never neutral. The courts recorded what they resolved. They left the rest to silence, and silence, repeated often enough, became their most effective instrument. That instrument required cooperation, though not coordination. Each participant behaved reasonably within their role. The clerk processed what arrived. The judge ruled when prompted. The jailer held those delivered. No one was tasked with asking how long was too long. The system assumed that time would correct itself. This assumption allowed disappearance to feel accidental even as it became routine. When questioned, officials spoke honestly. They described heavy caseloads, limited resources, inherited backlogs. These explanations were true. They were also insufficient. Truth can explain a harm without preventing it. The law's relationship to time was asymmetrical. It demanded punctuality from those it summoned, but granted itself flexibility without limit. A missed appearance could be punished. A missed decision carried no consequence. Power lay in that imbalance. Those waiting learned this quickly. They arrived early. They complied. They remained available. Their availability became invisible. The law noticed absence, not presence. As long as a person did not resist, their continued waiting required no response. In this way, delay favored obedience. Those who protested risked penalties. Those who endured were quietly consumed. The system rewarded silence by allowing it to continue. The deeper cruelty of this arrangement is that it appeared humane. There were no chains in the courtroom, no raised voices, no explicit declarations of removal. Everything occurred within norms admired for civility. This civility masked harm by making it appear orderly. When courts eventually confronted their own delays, they framed the problem as administrative rather than moral. They sought efficiency, not accountability. Faster processing replaced reflection. The past was left undisturbed. This left a historical residue that cannot be neatly resolved. We can trace patterns, identify structures, and name consequences. What we cannot do is finish the stories the law abandoned. The waiting ended only when lives did. The disappeared through technicalities and delay do not ask for vindication. There is no forum left for that. What they demand, if anything, is recognition that time, when controlled by authority, is never empty. It is filled with consequence, whether acknowledged or not. The courts believed that by waiting, they avoided injustice. What they avoided was responsibility for deciding when waiting had become harm. That question remains unanswered, suspended in the same silence that once held so many lives. That unanswered question is the inheritance of these courts. It survives not as doctrine, but as unease, a sense that something essential was deferred and never retrieved. In the end, the most revealing aspect of this history is how ordinary it was. There were no extraordinary laws required to legalize disappearance. Existing rules were sufficient. All that was needed was the acceptance that delay did not count as action, and therefore did not count as harm. Once that belief settled in, the rest followed naturally. Calendars expanded, dockets thickened, files aged, people waited. The law prides itself on memory. Precedent is its backbone, yet here memory failed by design. Unresolved cases did not become precedent. They did not teach. They did not warn. They simply remained unfinished and then forgotten. What we are left with is not a closed chapter, but a margin, a space where names appear briefly and then recede, where justice was promised, but time intervened, where disappearance occurred without acknowledgment. This margin is uncomfortable because it resists moral clarity. There is no single act to condemn, no statute to repeal, no verdict to overturn. There is only a pattern that reveals itself slowly, if one is willing to look. The courts that legalized disappearance through technicalities and delay believed they were protecting justice from error. They did not see that in doing so they protected themselves from accountability. Time became their ally, absorbing blame and dispersing harm. For the people caught inside this system, the experience was not theoretical. It was lived day after day without resolution. Their lives narrowed around waiting, and when waiting ended, it was often because there was nothing left to wait with. This history does not offer closure. It offers recognition. Recognition that justice can fail quietly, that harm can be procedural, that absence can be produced without violence. And recognition, however late, is the only answer these unresolved lives ever receive. That recognition comes slowly, because the harm itself was slow. It was cumulative, dispersed across months and years, imperceptible to those not living it. The disappeared were not taken in a moment, but erased in increments, a postponed hearing, a misfiled petition, a clerk on leave, a judge in recess. Each delay alone seemed harmless. Together they were lethal. The moral weight of this history lies not in spectacular cruelty, but in systemic invisibility. The courts that enacted it did so without malice, without threat, and without ceremony. They relied on what they called prudence, careful procedure, and the neutral passage of time. Yet their neutrality created absence. Their caution became erasure. Their patience became suffering. One can see this most clearly in the correspondence between families and clerks. Letters request updates, replies promise review. Weeks pass, replies grow vague, years pass. Eventually, the family stops writing, not because hope has been restored, but because endurance has been exhausted. Waiting itself has become the sentence. Even when reform came, it rarely touched the past. Statutes imposed deadlines, procedural rules, and term limits. They improved future cases. They offered protections for those yet to enter the courts. But they disappeared. Those already consumed by delay remained uncounted, unacknowledged, unredressed. Time had moved on, leaving them in the gaps. The disappeared are difficult to see because they do not appear in dramatic documents. They do not fill archives with scandal or fury. They leave traces only in absences, gaps in dockets, repeated continued notations, missing verdicts, and silent entries that never resolve. To follow them is to read silence as record, absence as evidence, and waiting as punishment. It is also to understand the quiet sophistication of authority. A court that disappears people through delay need not declare its power. Its power is exercised invisibly, continuously, and without resistance. It does not need spectacle. It needs only time and adherence to form. Those who survived such disappearance often emerged altered, if they emerged at all, aging in custody, laboring in uncertainty, or being transferred across jurisdictions without clarity of status. They returned as shadows of themselves. Their legal status might be restored, but their lived experience remained fractured. Recognition arrived too late, or in forms insufficient to repair what had been consumed by waiting. The courts themselves moved on. New judges arrived, new clerks filled offices, and the machinery of procedure continued uninterrupted. The vanished individuals became footnotes, their absence normalized. New generations of officials learned the rhythm of delay and unconsciously perpetuated it. The system had proven itself capable of erasing without acknowledgment, and the lesson was preserved more surely than any statute. In the quiet examination of this history, the horror is revealed not through spectacle, but through structure. A system designed for order, fairness, and impartiality became a vehicle for removal without crime. Its methods were lawful. Its effect was destructive. Its cruelty was procedural. It is in this intersection of legality and absence that the deepest lessons remain, that waiting can be weaponized, that patience can conceal injury, that the machinery of authority can remove presence without ever touching bodies, and that, sometimes, the law's greatest power lies not in its rulings but in its postponements. The disappeared through technicalities and delay challenge how we define injustice. They show that harm does not always announce itself, that suffering does not always have witnesses, that absence can be produced quietly, legally, and persistently. They remind us that the mechanisms meant to protect life and liberty can also render life and liberty invisible. And in studying them, one is left with a sober reflection that even within order, even within law, human beings can be undone simply by being left to wait. Time itself became the final arbiter. The courts never needed to act decisively because delay could do their work quietly. Every postponed hearing, every continued notation, every unanswered petition accumulated into absence. Those who waited experienced punishment not as judgment but as erosion of opportunity, of recognition, of life itself. This erosion was reinforced by social perception. Families learned that asking too often could irritate clerks or judges. Neighbors absorbed the silence as normal. Communities adapted to the unresolved cases by adjusting expectations. The disappeared ceased to exist not only in law but in memory. Absence became habitual, even invisible. Yet the law continued to present itself as rational, measured, and humane. Calendars were orderly, dockets precise, and procedures followed. Appearances mattered more than outcomes. The structure was intact, even when human lives were quietly consumed within it. Across continents and centuries, the pattern repeated. In colonial holdings, in frontier settlements, in growing industrial cities, the slow erasure of individuals by procedural delay remained constant. Systems that valued procedure over presence allowed disappearance to persist as a legal tool without acknowledgment. The law's neutrality masked its capacity to harm. In examining these histories, one must confront a difficult truth, that harm can occur without force, without intent, and without spectacle. That a system can be lawful, orderly, and respected, and still enact suffering. That absence maintained by process is itself a form of power. The disappeared through delay challenge our assumptions about visibility and justice. They remind us that those who are never called to account may nevertheless be the ones most deeply affected, that legal systems can absorb harm in silence, rendering it nearly invisible to observers, and often even to themselves. When the law finally moved, when a case was eventually heard or dismissed, the resolution rarely aligned with the life that had been suspended. Witnesses were gone, circumstances had changed, the individual had aged, deteriorated, or adapted. Justice arrived not in proportion to what had been endured, but according to what remained measurable and legally actionable. This is the paradox at the heart of these courts, that patience, so long considered a virtue of deliberation, became a mechanism of erasure. That care, so long considered a principle of equity, became a vehicle for absence. The very structure meant to ensure fairness could, if unchecked, undo the presence of the people it was designed to serve. To study these cases is to confront silence as testimony, to trace absence as evidence, to acknowledge that the law can fail not only through error or malice, but through postponement, inaction, and deferment. It is to recognize that time, wielded by authority, is never neutral. And so the disappeared remain. Their lives, their waiting, their erosion, preserved only in the gaps of ledgers, in the continued notations, in the quiet spaces between filings. They are absent, yet not forgotten, if one listens carefully. They are testimony to a form of justice that never declared its verdict, yet shaped countless lives. The weight of these absences is cumulative, felt not as spectacle but as quiet gravity. Each postponed case, each unresolved petition, each lapse in the calendar compounded upon the next. The disappeared were not isolated incidents, they were the predictable outcome of a system that valued procedure above presence. One could trace patterns across counties, across decades, across borders, names appearing, names fading, nothing bridging the two. It is tempting to imagine that such disappearances could be corrected, that attention or urgency could have restored what delay consumed. But the law itself offered no mechanism to reckon with absence. Its tools were designed for action, not reflection, for verdicts, not silence. And so the unresolved multiplied, safe within the bounds of legality, invisible because it did not break rules. Time became both sentence and erasure. Those waiting could not move freely. Their lives were measured, in calendar entries, in continuances, in the uncertain rhythm of judicial attention. Every postponed hearing altered their reality. Every repeated delay narrowed their choices. Every interval that passed without judgment widened the distance between law and life. The courts of this era functioned with remarkable efficiency in maintaining the appearance of care. Public confidence remained high because the machinery of justice appeared orderly. Judges spoke formally, clerks wrote legibly, files were meticulously organized. Yet within this order, lives were suspended indefinitely. Absence was contained, not addressed. Families and communities learned to live with this erosion. They adjusted their expectations. They moderated hope. They internalized the belief that patience was inevitable, that endurance was required, and that the law could not be hurried. Compliance was normalized. Resignation became survival. And as the disappeared slipped out of recognition, their absence became socially legible, though morally unresolved. Even when reforms introduced deadlines and procedural limits, they applied prospectively. The past, where so many had already been consumed by waiting, remained untouched. Those who vanished through delay were never counted, never measured, never compensated. They remained legible only to historians willing to read silence as record, absence as testimony. The moral horror of this history is structural. It does not reside in a single act of cruelty. It resides in the deliberate, lawful, procedural suspension of lives, in the knowledge that harm can be inflicted quietly, through forms, calendars, and pages, and can go unacknowledged precisely because it is lawful. The law, in its patience, became an instrument of erasure. To recognize this is to confront the paradox of legal authority, that it can enforce, protect, and obliterate simultaneously, that adherence to rules can displace responsibility, that civility and restraint, when unchecked, can harm as surely as overt force. The disappeared through technicalities and delay challenge our assumptions about justice. They remind us that the absence of action can be as destructive as violent action, that silence, when sanctioned and prolonged, is itself a verdict, that waiting under authority can become a sentence without a trial. And so the legacy endures, in ledgers with continued scrawled across pages, in names that appear briefly and vanish, in families that learn to mourn without acknowledgment, in histories that must trace absence to understand presence. The courts that legalized disappearance through technicalities and delay left behind no spectacle, no crime scene, no dramatic verdict. Only the quiet, unrelenting work of time as erasure. That work of time was precise, impersonal, and absolute. It required no malice, no coercion, no spectacle. It demanded only adherence to process. Each clerk, each judge, each procedural step functioned as a cog in a machine that consumed lives without noticing or needing to notice what was being lost. Delay became a form of authority, wielded without declaration, justified by neutrality and reinforced by habit. The disappeared existed in limbo. They were neither guilty nor innocent, neither free nor formally confined in the moral imagination of the law. Their status was unresolved, yet it carried consequences. They could not inherit, marry, or claim property. Their labor could be redirected. Their freedom was contingent on the schedule of others. The law had rendered them present only enough to matter administratively, and absent enough to matter socially and personally. In studying the archives, one realizes that the method was consistent across space and time. Colonial courts, industrial cities, frontier settlements, and early nation-states all practiced delay with the same quiet efficacy. The instruments varied: calendars, continuances, jurisdictional confusion. But the result was always the same: disappearance by procedure. The mechanism did not require oversight or even explicit intention. It relied entirely on process and patience. This structural erasure left marks that are subtle but profound. Descendants may search for evidence of ancestors only to find a gap. Legal historians may trace patterns only to find silence where a verdict should be. Communities may notice absence, but the law provides no narrative to explain it. The disappeared exist as a negative space within history, a void produced by lawful action in the passage of time. The courts could justify themselves at every step. They followed procedure. They acted within authority. They maintained civility. Yet in this very adherence, they perpetrated a unique cruelty, one that requires no spectacle, no evidence of intent, and leaves no one accountable except, perhaps, future generations who must reckon with absence as if it were presence. What remains is the lesson of patience weaponized. That waiting can be law's most effective instrument. That procedural delay, repeated and normalized, can substitute for judgment. That order and civility can conceal devastation, and that those most affected are often those least visible in the historical record. The disappeared through technicalities and delay teach us that law is never neutral. It is measured, ordered, and structured, but those structures can quietly consume lives. They can reshape families, fracture communities, and erase identity, all under the guise of propriety, fairness, and restraint. Their absence endures in the quiet of archives, the continued marks across ledgers, and the unanswered letters of families. Time itself has become the verdict, slow, procedural, unremarkable, and final in its erasure. And in that slow, steady work, the courts accomplish what force alone could not: the legal disappearance of those entrusted to them. The finality of this method is paradoxical. There is no dramatic conclusion, no courtroom declaration, no formal record of the harm inflicted. The disappeared did not vanish in a single moment. They were whittled away by calendars, by adjournments, by the neutral hum of bureaucracy. And because nothing officially happened, the law remained unblemished, even as lives were quietly consumed. This history forces a reckoning with what we consider justice. We are accustomed to imagining injustice as violent or intentional, as the dramatic failure of authority. But here, the failure was patient, procedural, invisible. Waiting became a mechanism of erasure. Silence became a verdict. Neutrality became a tool, and the system, obeying its own rules, carried out a form of punishment without ever acknowledging it. One can see it most clearly in the ordinary details: a file stamped continued 30 times across a decade, letters returned unanswered, a prisoner held while the court deliberated procedural points that might never be resolved, a family unable to move forward, unable to mourn fully, unable to reclaim inheritance. Each act alone seems minor. Together, they are devastating. Together, they constitute a disappearance sanctioned by law. The psychological and moral consequences were profound. Those waiting existed in suspended reality. Life continued around them, yet they were locked in limbo. Their identities became provisional, their agency constrained, their futures uncertain. And when the legal process finally moved, if it ever did, the individuals who had been suspended were never fully restored. They had been diminished by the slow, patient machinery of authority. Communities learned to live with absence as if it were natural. Families adapted, measured hope cautiously, moderated expectations. Silence became a protective strategy. The law, by never speaking clearly, ensured that no one would protest too loudly, that no one would demand accountability for what was slowly, systematically lost. This history also challenges our assumptions about culpability. There is no singular villain. No one official bears the full weight of responsibility. Each participant acted properly within the system. Each step was defensible, even necessary, and yet the cumulative effect was the erasure of lives. In this way, the cruelty was structural, not personal. It was the quiet horror of lawful procedure, of absence normalized by process, of time weaponized by authority. For historians, the disappeared present a difficult problem. They are not recorded as victims. They are absent in ways that archival systems struggle to capture. They are the negative space in legal records, the unmarked and unmeasured consequence of a system designed to preserve order over life. To recover their stories requires attention to gaps, to silences, to absences. It requires reading time as evidence, rather than assuming that nothing recorded means nothing happened. Even today, the echoes of this practice remain. Courts still manage backlogs, procedural delays are still defended as necessary, and the neutral passage of time continues to wield power over those subject to it. While reforms, speedy trial statutes, time limits, procedural safeguards mitigate future harm, they cannot recover what was already lost. The disappeared remain absent, not only from records but from collective memory, except in the fragments that diligent research can reconstruct. And so, the law's greatest lesson emerges from these absences, that authority exercised with patience, civility, and procedural rigor can inflict harm as decisively as force or violence. That justice is not only about verdicts delivered, but about time accounted for. That recognition withheld is itself a form of punishment. That silence can be as powerful and as destructive as any sentence. In studying these courts, one understands that disappearance does not always demand spectacle. It does not require brutality or notoriety. Sometimes it arrives quietly, through calendars, through delays, through the unremarked decisions to wait. And when it does, the law can preserve its authority while quietly erasing those it governs. The disappeared through technicalities and delay remain with us in these absences, in these gaps, in the quiet margins of history. Their lives were diminished, their stories unresolved, their presence denied. The ledgers do not mourn them, the courts never acknowledge them. And yet, through attentive reflection, through the careful reading of silence and delay, we can recognize them, if only faintly, and bear witness to the human cost of time administered as authority. The final part begins in the quiet weight of recognition. Here there is no dramatic revelation, no courtroom declaration, no neatly tied resolution. The disappeared do not return in force, nor are their absences fully recoverable. What remains is moral reflection, the slow, deliberate harm that authority can inflict not by action, but by inaction, not by decree, but by postponement. Time wielded as procedure became their sentence. Each adjournment, each continued notation, each procedural deferral was a measure of authority exercised invisibly, yet destructively. The law, in its calm rituals and orderly calendars, had erased presence without acknowledging it. Its restraint concealed cruelty. Its patience became punishment. Its civility disguised erasure. The human consequences were profound. Lives were suspended, identities made provisional, opportunities irretrievably lost. Families endured uncertainty across decades, uncertain whether to hope, to mourn, or to act. Communities learned to accept absence as normal. The disappeared were not violently taken. They were whittled away by the law itself, diminished gradually until recognition itself was denied. This history reveals a paradox of power, that authority can be most destructive when it appears neutral. That harm does not require malice, spectacle, or intent. That procedural propriety can consume lives with a quiet, methodical efficiency. The law, designed to preserve order, became a mechanism of erasure. It punished not through verdicts, but through waiting. It silenced not through force, but through time. To reflect on these disappearances is to confront the subtlety of injustice. It is to recognize that the absence of action can be as devastating as overt cruelty. That silence, deferred recognition, and procedural delay carry moral weight. That waiting, under the authority of law, can become a sentence in itself. The disappeared remain in the margins of history, visible only in gaps, absences, and the faint traces of incomplete records. Their lives resist closure because the system that consumed them left no clear narrative. Yet even in absence they testify to the quiet power of law, to the danger of patience mistaken for virtue, and to the enduring human cost of being left to wait. In the end, the lesson is subtle, somber, and uncomfortably enduring. Justice is measured not only in verdicts delivered, but in time acknowledged. Authority exercised without reckoning of delay can erase as surely as any execution, and those who vanish through technicalities and postponements remain with us still, a reminder that absence itself can carry the weight of history, memory, and moral responsibility. Their story closes not with certainty, but with quiet reflection, an acknowledgment that the machinery of law can shape, diminish, and disappear lives without spectacle, and that recognition, however belated, is the only form of restitution that time, once weaponized, allows.